Welcome back to another episode of Legal Stories. Today we're looking at the case of Kaela Katebe Kanswe versus Evaristo Mfuta, a significant appeal decided by the Court of Appeal of Zambia in 2025. This story begins with a family in Ndola. A woman named Constance Ngosa had two children, Kaela and Nelson, from a previous marriage. Sadly, their biological father passed away in 2009. In 2016, Constance married Mr. Emmanuel Kanswe. During their marriage, they didn't have any children together, but Mr. Kanswe embraced Kaela and her brother as his own. He changed their surnames to Kanswe and took full responsibility for their school fees, food, and clothing. Tragedy struck in June 2021. Constance passed away on June 18th. Just one day later, on June 19th, Mr. Emmanuel Kanswe also passed away. Because he did not leave a will, he is said to have died interstate. A conflict arose when it came time to distribute the estate, which included a house and shares in a company. Mr. Kanswe's brother, Evaristo Mfuta, was appointed as a joint administrator with Kaela. However, Evaristo and his family decided that Kaela and her brother were not children of the deceased, but merely dependents. This meant they would only be entitled to a small share of the estate, 10%, and would not be entitled to the house. They argued that because the children were never legally adopted, they didn't count as children under the Interstate Succession Act. Kaela took the matter to court, arguing that they should be treated as children of the family. However, the High Court disagreed, and the matter went to the Court of Appeal. The Court of Appeal had to look at Section 3 of the Interstate Succession Act, which defines a child. To clarify this, they looked at previous cases like Clara Chimfwembe versus Helen Mutale Chimfwembe. The court established that, under Zambian law, a child is strictly someone who is 1. Born during a marriage, 2. Born outside of wedlock, 3. Conceived but not yet born, or 4. Legally adopted by the parties to the marriage. The court also took note of the case of Macpherson Mutupambulo, which confirmed that even if a child lives with a person until their death, they are classified as a dependent rather than a child unless there is a biological or legal link. The Court of Appeal ruled that while Mr. Kanswe treated them as his children, the law requires a formal judicial process for adoption. Simply changing a surname or providing maintenance is not enough to create a legal parent-child relationship for inheritance. Because of this, the court dismissed the first two grounds of the appeal. However, Kaela won a major victory on her third ground. She had argued that the relationship between her and the other administrator was acrimonious or hostile, and she feared being cheated out of her entitlements. The court agreed. To ensure justice and finality, the court ordered that the house and all other assets be valued and sold at the market value. The proceeds were to be shared as follows. The 4 dependents, which includes Kaela and Nelson, share 10% of the total money. The remaining 90% goes to Mr. Kanswe's surviving mother. What can we learn from this judgment? Number 1. Surname changes are not adoptions. Changing a child's last name does not automatically make them your legal heir in Zambia. The importance of formal adoption. To give stepchildren full inheritance rights under the Interstate Succession Act, you must complete the formal legal process in court. The power of a will. This entire dispute could have been avoided if Mr. Kanswe had written a will. Court protection for dependents. If a family relationship is hostile, the court can order the sale of assets, like the family house, to ensure that even dependents get their legal percentage in cash, rather than being pushed out by other relatives. Each party was ordered to bear their own respective legal costs. Remember to write a will today. Thanks for joining us on Legal Stories. Don't forget to like, follow, and subscribe to our YouTube channel.